Okay, I think the next thing we want to do is I would like to hear some opening comments from the objectors. If you would, please state again your name for the record, and this is an opportunity for you to make some opening statements.
Thank you, Mr. Chairman. My name is John Castle. Objector David Castle cannot be here today and has appointed me as his attorney in fact, not attorney in law, but attorney in fact, to represent him at this hearing. A letter of appointment, his letter of appointment, has been filed with City Clerk Johnson. County Clerk Sharon Holmes is here, and she is available to attest to the number of registered voters in the city of Dekalb at times germane to this petition. Objector Mike Larson, of course, is here in person. In the interest of time, we'll combine our presentations and talk only about the first objection. The first objection, that the number of signatures is insufficient, determines the issue. The issue being the sufficiency of the petitions. Article 7 of the Illinois Constitution of 1970 established the city of DeKalb as a home rule municipality. Article 7 provides that home rule units can, by referendum, elect not to be a home rule unit. And that's what this is about. It's abolishing home rule, electing to not be a home rule unit. Section 28.7 of the Election Code says that in any case in which Article 7 authorizes any action to be taken by or with respect to any unit of local government, subject to approval by referendum, any such public question shall be initiated in accordance with this section. In plain English, the Illinois Election Code 28.7 exclusively governs the right granted in Article 7 of the Illinois Constitution to hold a referendum to elect not to be a home rule unit. Section 28.7 sets out the requirements for initiating a home rule referendum. Any such public question may be initiated by the filing with the clerk or secretary of the governmental unit of a petition signed by a number of qualified electors equal to or greater than 10% of the number of registered voters in the governmental unit, requesting the submission of the proposal for such action to the voters of the governmental unit at a regular election. Again, in plain English, a home rule referendum petition must be signed by 10% or more of the municipality's registered voters. Sharon Holmes has certified that there were 22,760 registered voters in the city of DeKalb when the home rule petition was filed. 10% of that, of course, is 2,276. The petition for referendum, which is the subject of this hearing, contains only 782 signatures, less than 1/3 of the number of signatures required by the Election Code. For that reason, the petition fails to meet the requirements of the Election Code, Section 27, and therefore the home rule question should not be placed on the ballot as requested by the petitioners. The 10% requirement is a high bar. It's a high bar for home rule referendums, pro or con, to be placed on the ballot, and that's as it should be. This is a big issue and an important issue, and we can talk about that at another time. But in the spirit of sticking with the point that is before this group, as you requested, Mr. Chairman, we'll defer with that and simply say that the Constitution and the Election Code very clearly say that 10% of the registered voters must sign the petition for it to be valid, and for it to result in putting the referendum, putting the issue on the ballot. That test has not been met, and we submit that the petition not be granted, that the issue not be put on the ballot. Thank you.